Hello and welcome. Arguably the preeminent public intellectual of our times, Pratap Bhanu Mehta has characterized the Supreme Court's upholding of the PMLA, the Money Laundering Act that gives the state arbitrary powers over citizens, as the apex court's stamp on Kafka's law. Rather than being the guardian of rights, he said, the Supreme Court now is a significant threat to it. Mehta is not the only one in his criticism of the Supreme Court's judgment. Other legal commentators have described Wednesday's judgment as a veritable license for executive excesses, as the making of a police state. Here's a brief look at some of those contentious provisions. The PMLA does not follow many principles that are the bedrock of criminal law. Under this law, an accused person is presumed to be guilty, not innocent. There is no judicial oversight of the investigation. Self incrimination is permitted through statements given to the Enforcement Directorate. Further, in the initial stages, a person can intentionally be kept in the dark about the crimes of which he or she is being accused. Once arrested, bail is nearly impossible. The ED can also, without judicial oversight, attach properties of an accused person even before charges have been filed, thus financially crippling them even before trial. Now, under the Narendra Modi government, the use of the law has increased exponentially. Between 2004 and 2014, under the Congress, the ED carried out 112 raids. But between 2014 and 2022, there have been 3,010 raids under the BJP, a 27-fold increase. In addition, the conviction rate remains abysmally low. In around 5,400 PMLA cases in 17 years, there have been only 23 convictions. And a closer look at who is being prosecuted under the law gives credence to the belief in many quarters that the ED is being harnessed by the government to go after its political adversaries. Senior advocate Nitya Ramakrishnan will help us understand Wednesday's judgment and the implications for individual rights versus state powers. Thank you for making the time, Ms. Ramakrishnan.
Thank you so much for having me on your program, Smita.
Well, to begin with, ma'am, the state's chief argument in court, which also appears to form the basis of the Supreme Court's judgment, relates to India's commitment to what has been an international consensus on bolstering domestic laws against money laundering. The judgment says money laundering is an offense against the sovereignty and integrity of the country, that it has transnational consequences on financial systems, and therefore, given the gravity, a departure from certain established principles of or safeguards in criminal law is justified. Now, am I reading that correctly, Mr. Ramakrishnan? And if so, can you sort of comment on this reasoning?
Well, perhaps not in as linear and as stark a way in which you have put it, but there is no doubt that India's international commitments on this point has weighed greatly with the court in upholding an expansive definition of the offense of money laundering itself under Section 3, reading and as or, in upholding the burden of proof provision under Section 24, in upholding the restrictive powers to grant bail, and in general, in converting is into ought. That this is the way it is, this is the intention, these are our commitments, and therefore, this is how it ought to be. And of course, India also has commitments under the ICCPR. India has a commitment against compelled self-incrimination. India has other commitments also, but those have not entered the process of upholding provisions which you have described in your introduction.
Right. Can you speak to? Can you help us understand the what is called the legislative intent of the PMLA? Now, a perfunctory look at the law would suggest that it was originally meant to deal with proceeds of crimes such as gun running, drug trafficking, terrorism, etc. What was the original legislative intent of it, and how do you see the subsequent sort of amendments to the PMLA and whether that's been in line with the objectives?
See, the stated purpose is they see that there is crime, there's international crime, there's drug running, there's terrorism, and worse. And they see that proceeds of this or funds used in this get seamlessly integrated into the world economy. And so this is the stated purpose of this law. However, individual statutes like the NDPS and the UAPA themselves have a mechanism to deal with proceeds of crime or crime used in those offenses. I think Chapter 5 of UAPA and Chapter 5A of NDPS have these provisions also. So, frankly, to me, there is a scheduled offense. That offense may often have a provision for adjudication and confiscation also. So, frankly, I have not understood personally this overarching legislation, however lofty its purposes. But the stated intent is what you said and what I just said.
uh, I figured in my conversations with my colleagues that not everybody is familiar with this sort of relationship between scheduled offense and the proceeds of that particular scheduled offense, and how the ambit of the scheduled offense is sort of widened. Could you sort of in simple terms help us understand this?
I'll try. See, there are about over 150 offenses or statutes, penal statutes and other statutes listed in the schedule to the PMLA. These are what are called scheduled offenses. So if somebody is being prosecuted for one of those offenses and some proceeds, some property, something is derived from those offenses, then the PMLA seeks to address that and its transition in trying to prevent it and trying to confiscate it. So there is already a prosecution on under the laws of the land. Many of those laws themselves provide for a confiscation of these properties. Yet there is the PMLA, which now expands the definition of what amounts to dealing with proceeds of crime. The section itself says where there are proceeds of crime, that is, crimes derived from the commission of one of those offenses in the schedule, and there is projection of it as untainted funds. It is an offense. However, there is an expansive explanation to it, which has come by way of an amendment, which has a series of or, so concealment, use, etc., etc., and attempts directly or indirectly to do any of this, gives an impression that virtually anybody, even somebody who may happen upon something which you trace as a proceed of crime or posit as a proceeds of crime, connected with another offense and another prosecution under another statute, will be covered by this law. So one of the arguments of the petitioners was that, well, at least read it as and, because that is what the main section says. And the explanation, which seems to expand it into or, cannot really determine the nature of the original section. And you have to go by the original section. But here the court has, among other things, relied on India's commitments and the larger purpose as they see behind this law, and say, therefore, we will read it in this extended way. Another thing is, it was argued that by an amendment, see, there is a schedule, as I said. Normally, under criminal law and as per the Constitution, you can only be prosecuted for something which was an offense on the day when it was committed. But under the PMLA, assuming that there was something which was not a scheduled offense, because the entire PMLA is really, at least textually premised on those scheduled offenses. So it was argued that if on the day of the commission, some act was not a scheduled offense, then PMLA cannot be invoked against an offender who comes under that category. But by way of an amendment, a continuing notion has been introduced that even if an offense was not a scheduled offense on the day of its commission, if the proceeds of crime continue, then they can be proceeded against under PMLA. And you can imagine, after all, money is money. Note pe thodi likha hota hai. So this expanded definition is so inchoate that it is a criminal law, a criminal provision has to be clearly defined. It must admit of clear proof. These are time honored features of criminal law, which seem to be somewhat set at naught by these amendments, these definitions, these expanded understanding of continuing proceeds of crime. And therefore, even though something was not part of the schedule on the day it was committed or allegedly committed, we will treat it as being part. So these are all expansive definitions which have been premised, among other things, on India's commitment,
Right.
international commitments on this. And as I said, India has other international commitments under the UDHR and ICCPR, which really we should not lose sight of when we look at both the judgment and the law.
Right. Ms. Ramakrishnan, one other sort of cornerstone of criminal law that appears to have been appended is the presumption of innocence. Um, could you, for the benefit of our viewers, explain why this is a necessary, why presumption of innocence before a trial is completed is principles of natural justice, and how this has been appended under the PMLA, and how the court somehow didn't see in this as see this sort of provision in the law as being unreasonable.
As I said, Section 24, which creates the presumption against the accused person, has been upheld also on an understanding that the menace is so immense that such a provision is in keeping with the need of the times. See, this is not the first time that a deviation from established criminal jurisprudence has been made. The terror laws, which diluted due process requirements and which later we had to repeal them or allow them to lapse because of gross misuse. This sentiment that there is such a menace that we do not need to adhere to normal principles of criminal jurisprudence has led to all kinds of people being roped in, kept in jail for many, many years. This has happened before, and perhaps it is happening again. But the sentiment is not unknown, and courts have upheld POTA and TADA on similar considerations. And it has led to human rights issues, civil liberties issues, and so on and so forth. The presumption of innocence, it is based in civilized countries. This is based on a plain understanding that the individual is pitted against the might of the collective. And the consequences of a criminal process are dire. It may involve loss of liberty during the process and even after the process. In these circumstances, to counterbalance this unequal, to bring some balance to this equation, some rights are given to the accused: the right of silence, the presumption of innocence, proof beyond reasonable doubt, the right to know the grounds of arrest in detail, because oftentimes the accused is in custody throughout the process and is therefore disabled from presenting the kind of defense a free person may do. Also, you see, PMLA is a very strange law because it allows for a joint trial of the scheduled offense and PMLA. So a person accused of a PMLA offense will be also tried for the scheduled offense with the same staff being brought into evidence. So protections which are available under the other laws, for instance, a statement made to an investigating officer, police officer, will not be admissible. Some of these things may get diluted unless the same conditions are imposed under PMLA also, which does not seem to be any longer the case. So it skews fundamental principles of criminal jurisprudence in many ways.
That then brings me to the question about bail, the twin bail conditions. Can you help our viewers understand, first of all, why this is seen as draconian and an impossibly high standard to meet for an accused, and how the Supreme Court again seemed to not be moved by what the petitioners argued in court?
See, these twin conditions have been there in TADA, in POTA, they are there in MCOCA, and they are there in a slightly different form under the UAPA. And they have been a matter of concern to those concerned with civil liberties, because even otherwise, a court is to consider many things before granting bail. And that is the seriousness of the offense, the likelihood of repetition, and so on and so forth. But to impose fetters on judicial discretion to ensure liberty is always a matter of concern. Over a period of time, they've been interpreted and reinterpreted by various courts. For instance, the slightly modified words in UAPA, that is reasonable grounds for presuming that the accused is guilty instead of saying not guilty, has now been held by a three-judge bench of the Supreme Court in Najib as being a lesser threshold for the accused. Uh, and the Supreme Court has also held that with passage of time, these conditions get diluted. But Nikesh Tarachan, in the context of PMLA alone, this provision was struck down as unconstitutional. It has been brought back with a slight difference, but it has been brought back, and it has been also justified on the ground that the menace is dire. It is, of
Right.
course, difficult. And also, you must remember that PMLA, as I said, has implications for other offenses. Over 150 statutes, criminal statutes, and other statutes where people can be prosecuted are linked to PMLA and will be the subject of a common trial before the special court, or both trials before the special court under Section 44. And long periods in jail and difficulty in obtaining bail are serious issues for liberty. A court anyway has the discretion not to grant bail if it appears that it would not be in the interest of law enforcement or of justice. And there's always provision to seek a cancellation of bail, or stringent conditions may be imposed for grant of, in the sense, bail conditions may be imposed that somebody cannot leave the country, passport must be deposited, and so on. But these provisions remain.
Right. So, for those not fully conversant with criminal law, Ms. Ramakrishnan, just to clarify if there is some confusion, the PMLA, which is a special law, overrides other sort of
The normal
CRPC
CRPC provisions on grant of bail. It
of
is not
grant.
only the PMLA, but the UAPA does it,
Right.
MCOCA does it, the
Right.
NDPS Act does it. That is a normal consideration. Normally, even a magistrate may grant bail if the offense is punishable with 7 years or less. And you see, PMLA by itself normally carries a maximum of 7 years. Though
Right.
on occasion, if the scheduled offense is under the NDPS Act, it may extend to 10 years. But so normally a 7-year sentence under the
Right.
CRPC, the Supreme Court says, and even now the CRPC says, that normally even arrest should not be necessary. And
Right.
after all, if you look at the PMLA, it is only that the actual offense is being prosecuted and you suspect that there are proceeds of crime. You can address those proceeds of crime by confiscating, etc. But you additionally want to criminalize it over and above the criminalization of the actual act, which, in my
Right.
opinion, kind of includes crime, the crime of
Right.
whatever falls, the fallout, or whatever benefit, or what monetary or property benefits have been derived from that crime. As a criminal act, in my opinion, that is covered. But in any case, you want to separately penalize it.
Right.
And then there are twin conditions which will end up applying to that person, even if the statute under which the main of scheduled offense is being prosecuted does not have these conditions. Because in
Correct.
effect, because of this, the person will continue to be in jail. So the normal discretion a high court or a court of sessions may have to grant bail, because it comes to the conclusion, because otherwise there is jurisprudence that even if there's a prima facie case, sometimes you must grant bail, because ultimately there's always a possibility of a declaration of innocence.
Correct.
So these principles kind of get skewed with the imposition of such conditions.
Right. And if I'm not wrong, there are certain offenses under the schedule offenses that are even non-cognizable offenses. So, and despite that, these sort of twin bail conditions stand. In conclusion, Ms. Ramakrishnan, we've been hearing from legal commentators since Wednesday about how this is hugely consequential as a judgment on how the judiciary deals with this question of state power versus individual liberty. And I started this conversation by quoting Pratap Bhanu Mehta and how he's sort of disappointed with the manner in which he says this is the Supreme Court, in his opinion, is more executive minded than the executive, he said. I wonder, in conclusion, what your thoughts are on this very question of how the apex court of the land looks at state power versus individual liberty.
See, I'm intrigued really how this judgment is going to play out. First and foremost, the principle of self incrimination. Our constitution as well as our statute says there can be no compelled self incrimination. There is a right of silence. So, if for any offense you're being interrogated either as a witness or as an accused, you can tell the investigating officer, the policeman, I will not answer this question because this will incriminate me. This is under section 161 2 of the CRPC. This was called by Justice Krishna Iyer, I think, a statutory gloss over the constitutional clause or something like that. That is Article 23, which says no person accused of an offense will be compelled to be a witness against himself. But this has been expansively interpreted to say even if there's an imminence, that is in the Nandini Satpathy case. Aside from this, there are provisions in the Indian Evidence Act, sections 25 and 26. 25 says nothing said to a policeman will be used in evidence against any person accused of a criminal offense. 26 says no person in police custody, no statement made by any person to anyone in police custody can be used against that person in the prosecution of any offense against him if it is not made in the presence of a magistrate. Section 162 of the CRPC says no statement made by anybody, either a witness or an accused person, subsequently an accused person, will be used as evidence in the trial. So the principle is very clear. No statement unless made voluntarily, say by way of a confession to a magistrate, or an admission of guilt in court, or in very, very limited circumstances, statement made to the police, only that portion which directly leads to the discovery of fact, can be used against anybody. Even as a witness in a court of law, section 132 of the Evidence Act says you can be compelled to answer a question even if it incriminates you. However, you're immunized from the consequences of prosecution for whatever you say. So this is a statutory scheme. Now, in this judgment, the court has said, A, this is not a pure criminal statute. The statement, the AD officials are not police officials. And therefore, the immunity you have while you're being interrogated of under section 162 CRPC or 161(2) will not apply. However, there's an ambiguity. However, if the statement is taken after arrest, then section 25 of the Evidence Act may apply. This intrigues me because section 25 of the Evidence Act has nothing to do with arrest. It's any statement made to a policeman.
Right.
Then there are other three-judge bench decisions which say that any official, whether designated as a policeman or not, if has the power to interrogate, investigate, extort a confession, then that protection should apply. But this selected thing, section 25 is a rule of evidence, it may apply, it may not apply. It's not really only a rule of evidence. It signifies the constitutional protection against self-incrimination. And we are also internationally committed to a position against self-incrimination. And PMLA having repercussions with regard to other serious offenses, which have that immunity, but you're subjecting them all to a common trial with this very ambiguous position on self-incrimination. So how this is going to play out as far as individual liberty goes? Then there is a serious threat, because what the Supreme Court has said in this judgment is, if the statement is taken after arrest, then section 25 may apply. Now, what prevents an ED officer, knowing that arrest is imminent, from taking a signed statement on oath and then thereafter arresting? So then what happens? What are the implications for liberty? And most of all, the question is, how will this play out in the face of section 24 of the Evidence Act, which is no confession will be is relevant or will be admissible if it appears to the court to have been made under compulsion from a person in authority, on the count that you will either avoid some discomfort or some evil. Now, a needy official who can compel a statement on oath and actually prosecute you if he believes that the statement has either not made or not made according to, is not correctly made. Is that not a compulsion from a person in authority? How will this explanation of Section 50, a statement made on oath, play out against Section 24? These are all challenges. And as one senior counsel said when the judgment was delivered, is that these matters never end. So, how will this play out against other three judge bench decisions, Nandini Satpathy, Tufan Singh? When you say this is not, if he's not a policeman, then how does Section 25 kick in suddenly? How does it not kick in? So, these are all ambiguities which we will have to be worked out.
All
And of
right.
course,
Right,
there
go
was a
ahead.
sorry. No, there was a time when, you see, customs officials were held not to be police meant for the purposes of sections 25 and 26 of the Evidence Act.
Correct.
But those were all proceedings which led to very, very trivial consequences, often punishable only with a fine, summary trials. But as I said, the PMLE has repercussions for other serious scheduled offences. Forced into a joint trial, there is no evidentiary statement in the Act itself of whether it's admissible or not. And therefore, an ambiguous statement on when Section 25 may kick in, may not kick in, it'll have to be reconciled with established jurisprudence and certainly with Section 24 Evidence Act, to my limited understanding.
All right. I appreciate you making the time, Nitya Ramakrishnan, and for helping us sort of understand what is clearly a complicated subject.
I
But
hope
at
I've
the
not
end,
complicated it further, and I hope I've not
no,
been too obtuse.
not at all. In fact, I certainly have a better understanding before we started this conversation on a Saturday, as I said. Thank you, ma'am. Thank you for making the
Thank
time.
you very much.
Thank you.